Test 1 2, check 1 2. Testing 1 2, check 1 2.
Good morning. This is the Flagler County Board of County Commissioners special meeting. Today's Monday, March 9th, 2026, and it is 9:01 a.m. If everyone could stand for the pledge. Now we'll take a moment of silence to pray and reflect on the men and women who are serving us here and abroad. Thank you. Okay. Good morning, everybody. Welcome to today's special meeting. I think we're going to go ahead and get it kicked right off. We're going to go into item number 4. That is the selection of an acting county administrator. Will HR be presenting this morning? Anything? No? Okay. Do we have any discussion from the administrator or the attorney first?
Well, I think this was for you guys to discuss the route you want to take. Leave it mainly as an open-ended discussion, whether you were going to discuss whether you wanted to have an acting and then have an acting kind of transition to an interim and use that interim to then serve during the time frame before you find a permanent, or do you go straight to naming an acting who will be acting as the, acting while you name a permanent? So this is a chance for you to have an open discussion as to the process that you want to undertake. It's really going to be an open-ended discussion. Don't have really any set framework for this. I think you guys wanted to kind of discuss the what's going to be the process or what's going to be the framework for how you want to conduct this transition.
I appreciate it, Mr. Rodriguez. I'll open it up to the board. There was, I believe, some emails sent out by HR earlier in the week of some information from how to recruit. Some topics there were given to us, groups that involved that. So I will open it up and allow anybody to start with any research they did or any discussion they'd like to have about how they would like to proceed.
Well, why do we need an interim? Why don't we just
I don't know
go
how we
start the process and find somebody?
Right.
And we have Heidi here to run the show while we're doing that. So I don't know why we need to pick an interim, because if we do, we're taking somebody off their job that they here on the county that they're doing already. So I don't see the need.
Okay. Anyone have any discussion down here for what they believe to be the next steps? Mr. Dance, anything at this time?
I'm waiting to hear. Was not in the majority last time, so I'm anxious to hear what the majority has to say.
Well, we had talked about, I don't know if you want to go before I talk, but we had talked about Ms. Petito had volunteered to stay on through the end of, or middle of July, apologies, and doing either an interim or a full-time acting manager search. Some information was sent to us about how you can proceed with a search. Is that something we wish to discuss today to go ahead and kick off? Would you want an interim to come in for a year from one of those retirement type agencies or retired previous counties, or would you like to go ahead and do initiate a search for a full-time county administrator? We're going to need some input, folks. I got your...
I think we have to,
Yes, understood
start
that.
the search. Let's get
Okay.
going on this.
That's an immediate choice right now, is to get a search. I did look up some information about having possibly the role done by two different people for two different department heads that have assistants and help that is in their department. if they could come and work together on doing administration because of the need to get things going rather than just stay, how do I put it, stably what we're doing right now, what we've been doing, and that change is good, and we need to make the change at the time that we plan to get things in a better, different direction. If somebody's unhappy, the worst thing you can do is make them stay unhappy. That's my opinion.
Okay, so sounds to me like you're in favor of
Interim,
an interim
yeah.
from our existing staff.
From someone or two,
Okay.
from our existing staff to step up and
Okay.
fill their expertise in the role on things that are necessary to be done until our regular new
Okay.
administrator would be hired.
All right. And Mr. Dance, I know that you had information you'd asked to be sent to us regarding FAC. Could you give me some background on how the FAC works?
Sure. They, through the Florida Association of County Managers, they do a process. I shared the information with HR and with the attorney on their process. So it does include contracting with them. They come in and as you've seen with other searches that have happened, either with the city or the school district, it involves us getting together to look at the qualifications, what our expectations are out of the job, community involvement, and a search. Right, we set the parameters for what we want in the search, but it can be, an expedited process. Probably could be 4 to 5 months. An extended version with more community input could extend beyond that. There weren't any fees involved at this point. It was just information gathering from them.
Did you have any sense of how long it would take to seat a person from that search? Typically, did they?
I think it depends on right. We could get a selection done potentially in 4 to 5 months, but it may take a little bit of time, depending on who the person is that's selected, on what, how much time they have to give.
Right. Are they mainly, understanding they're mainly previously served in the role, they don't serve anywhere now, they're mainly like retired or unemployed? Is that typical for that?
No, it's just an open search. They
like
could be anywhere. Current positions that they're moving, it's,
And are you thinking for?
current deputies that want to advance.
Are you thinking for an interim from that search and then to come in for several months and then go to a permanent search, or?
No, that process is to help you select a
That's
permanent.
Okay, what about and I'm sorry, I think Ms. Carney had done some search on it. You had talked about rangers, the temporary for interim.
We on?
You gotta go flip it up. That's it. It's new.
Okay. I basically found the same information. There's no such thing as rangers anymore. They moved into a consultation role. I think we need to be a little bit cautious on the interim word. We went through this with the county administrator as well, right? So you use the word interim. We got, interim implies that they may be in line to, take over the role. I did review some of the folks that did respond to HR's shout out, and at this point, I would not lean towards trying to bring anyone that far away in here. I'd like to start the search. Again, I'm not in the majority here, but I do like to use professional services, professional paid services. I do know, I mean, I don't see why we couldn't use, you know, the league, I call it the league, Florida Association of Counties. Again, I think there's more research that needs to be done by HR. We can do it internally like we did our attorney, but I'm not for taking staff and moving them into a role just to be a acting administrator. I don't know what the pool of qualified people, I don't know what the pool looks like. Palm Coast had a struggle. We could possibly face the same struggle. I think until Mrs. Petito pushes our hand, what I mean by that is she finds another employment and needs to leave before July. I mean, I think that is a possibility. I don't know. Or we do the search and the right candidate is here before us. So
Okay.
we'll have to be open to workshops, you know, interviewing, narrowing it down. We don't know until we go out and get the applicants. But
So it sounds to me like,
we could start on our own and see before we hire. I know I'm not going to get a vote on that, so, but I'm not opposed to hiring a professional firm.
all right. So from what I'm hearing today, it sounds like the direction the board would like to take is to continue to keep Ms. Petito in her position and role and start a search process through, at least through the FAC process, it sounds like, and see what it yields. And if we're not satisfied with the yield, we can talk about professional services coming in. Does that sound right? Did I capture that right?
That's my preference.
Say again?
So we would keep Ms. Petito in her role as she currently is and start the process to search for a county administrator through FAC, through our Human Resources Department here, and then see what the yield is on it and if we're comfortable proceeding with interviews or if we need to go out for a professional search from there, which we can have that discussion in a commissioner comment at some time. Is anyone comfortable with that, not comfortable with that? I'm fine with that.
Look that way. I think you got this side.
Yeah, I do. Sorry, I'm looking down there. Looking, I know that's where you stand, which is to keep, you're okay with that. You would prefer to go ahead and place, but I don't hear that from everyone. I would feel comfortable having at least someone as a backup to Ms. Petito from our existing staff. Should anything happen, you know, we don't have any backup right now.
Well, because she doesn't have a deputy,
Yeah.
you're probably right on that, because if she's got time off.
Not
if
to mention
something-
just for work balance, to help her out and everything else. If she has time off for PTO or sickness, it would be helpful for her to find someone if she, you know, from staff that could help. So,
That was the reason with the empty seat that I thought if we had two board leaders, directors, that they would be able to keep a balance rather than a solo, which we've never had until now.
Well, if that's what we were saying we want her to do, then we should ask her to
right,
pick somebody.
that is in her purview to do.
Yeah, it's in her purview to do that.
Correct.
Ask her
Correct.
to- if she would please do that.
And it would be just a person to fill in
Right.
as
Just so she
backup
has a
as needed.
deputy. Yeah.
Because that's technically in her purview to a point.
Yeah.
I'm just going to, I think I have an idea where everyone is here, but
It's fine.
are you comfortable with that?
Andy had something he was
I
going to
think
say,
Mr.
I
Jantz
think.
is thinking.
No? You were waiting? Oh, I didn't know.
No, just a little out of the box thinking. everybody's familiar that Chief Strobridge temporarily filled in to help the city of Palm Coast, and in a role similar to how Jerry Cameron came in a period of time to stabilize the county. I didn't know if there was any thought of looking at, obviously he would have to break from the sheriff's office. It would be a hard break. We couldn't do what the city did, but we could reach out, have the chair reach out and see if there was a willingness.
Have you talked to him about it?
Briefly.
I have. I don't think it works.
Okay. Just throwing it out there.
Yeah, I mean, I don't know. I don't know what breaking with the sheriff and how the staff would feel. I understand what you're saying, but then
Well, we just said it's on Mrs. Petito, we just said it was on her to find that person, not on us, right?
I think
So
you're
let's give
thinking of in lieu of Miss Petito.
Oh, in
Is that
lieu
what
of?
you're saying?
Right.
Right, so that Miss Petito
Oh.
can move on.
But just, again, we're throwing ideas out there, and, I mean, I understand that there's complications with it, at least perception, public perception and stuff. That's why it would have to be a complete break, and it would have to be near unanimous, because something like that doesn't happen with a split board, so. So it sounds like your path with the
I
path
think
we've
I
discussed.
guess my question for Miss Petito is, would it be helpful for you if you moved on sooner than July? I know that you wanted to stay on or had offered to stay on through budget. Obviously the majority of the board is comfortable with you staying till July. But, I don't know what your personal, commitment or what you're looking for outside roles, if that's not helpful for you.
I'm not worried about seeking outside employment. I will say, again, that this item was scheduled to return on March 16th at a workshop. I think putting it on today is unnecessary. I just think that it continues to display a very sloppy approach to trying to find a transition. When you decided that you wanted to change in leadership, I said that I would be willing to stay on to tentative budget. I still feel that way because the budget is the most important thing that you guys are responsible for in county government. I said I would stay on until we got to tentative. We deliver that on July 13th. My last day would be July 14th. Okay. There was discussion among the board that wasn't happy. Rip the Band-Aid off. I think somebody said, make the separation immediate, let her go now. This is sloppy. This is not a professional look. I'm here as a professional. I will stay on. But if we could continue to act as professionals and move forward with the budget while you all search for a permanent replacement, that would be wonderful. Thank you.
I don't know. I just came to the meeting. They said we had too much for the workshop on Monday, that they were splitting it up. So it ended up on today because today I didn't do it.
We didn't do it.
So. Who put it on? But there was too much for the workshop for the 16th, so they split the workshop up.
Whose choice was that?
They canceled.
I believe it was the county attorneys who set the agenda for today's meeting. It
But
wasn't
I wouldn't
me.
take that personal. It was just there was too much workshop. To workshop on the 16th. It still sounds conflicting, so I understand where Mr. Dance is now that I've heard this. I have talked to Mr. Sturbridge. He did reach out and offer services. I wasn't thinking of it, to be honest with you, because I wanted to ensure that the staff was comfortable with who they worked with through July, and they had an opportunity to see who was interviewed for the role, and have that relationship there. But there continues to be some strife, and if that's the easier thing to do, then I'm open to it. I'm open to it. He would have to cut complete ties with the sheriff's office, though, before I would consider it. So. but I can see,
I think
You
the
know,
way you
Ms.
stated
Petito's-
it a minute ago is what we should do.
Yeah.
Let's just do that and start
Yeah.
the process now.
Well, if that's the plan, this is a regular special meeting, I'll motion that we have Human Resources reach out to the Florida Association of County Managers and bring information back to start that process.
Second.
all right.
So, all right, we're just going to have to play it by ear. If it doesn't, if we really can't work this out, then we can come back at any time and redirect,
Okay.
okay?
One, I know we have a motion and a second. Is there any clarification on having an interim deputy in case of, is there anything, a direction for Ms. Petito on that?
Well, we could ask her.
Is anybody
Nicely.
comfortable with that?
I mean, again, we only hire and fire 2 people, so it is up to
She'd
Ms.
like to.
Petito
I know, I
to
would
fill
feel
out
more
her.
comfortable having a secondary person to go to and for backup for
Right,
her.
she can reach out to
Okay.
whoever within staff to help her. It could be multiple people to help her.
But if the search results in another candidate that we all agree on, or majority agrees on, is July a hard date? I mean, do we hire somebody tentative on July 14th start date
No, the separation agreement said or sooner.
or sooner? Okay, so we find the candidate.
Right.
If we don't, then we're going to have to, then we'll have to regroup, I guess, and then do the interim or acting or whatever.
All right, I have a motion made by Mr. Dance to retain Ms. Petito till July in a search by FAC and our Human Resources Department.
We made that decision earlier, so that was not part of the motion. That's
Okay.
already been decided.
Okay,
So it was just to have
hire.
HR reach out to Florida Association of County Managers.
I have a second by Mr. Hanson. Can I go open this up for public comment? Is everybody comfortable with that? All right, I'm going to open up item number 4, the selection of an acting county administrator for public comment. Those wishing can approach, state your name. You have 3 minutes, and you can direct comments to the chair. Okay. Seeing none, I close public comment on this.
Just to
Bring-
clarify,
oh, sure.
so we're only going to FAC? Your motion was just to go to FAC?
Just to go to FAC.
I thought we've talked about a step, I'm sorry, I can't talk this morning.
All right.
We've talked about going to FAC, we've talked about hiring a consultant, right?
The motion was not to do both?
It did not include that, correct.
Right.
So is that the only direction we're going to go?
They are, by default, the consultant that we're hiring to lead us through this process.
But it's just not a fee, is that the
No,
difference?
they will have a fee as well.
Oh, okay.
They're going to have to dedicate manpower to this.
Yeah, just asking the question.
Did we get a quote?
No.
And who's the lead on that, do we know?
HR.
HR.
No, the lead on the, from
Who at FAC? Who at FAC? What department at FAC?
Well, Emily Anderson is the staff person who would lead that.
Emily?
Emily Anderson.
No, okay. Before we make a decision on that, should we know what the cost is? No?
It's probably, from what I could tell, reading through everything, going to be in line with, maybe even less, it looked like, than the
Than
public
a firm?
search. Yes, because this is the role
Than a private
of
firm?
FAC, just like League of Cities is for cities. You know, and they have a good, they have a good pool, a better pool than probably an outside would have. We can always come back to the outside. But I feel like FAC is the right. for
Well,
this
it should be the
situation.
leader in the industry, of course, so.
Well, I think importantly, especially with outreach and connections within Florida.
Resources.
I mean, personally, I think, a Florida-focused, even coastal candidates would be highly important for us. But
And rural.
Okay.
We need a little bit
So
of
we
everything.
have a motion by Mr. Dance, a second. We've gone out to public comment. We're going to go ahead and do a roll call vote. Is everybody comfortable with that? Sure. Clerk?
Commissioner Hanson,
Yes.
Commissioner Carney,
Yes.
Commissioner Richardson,
Yes.
Chair Pennington,
Yes.
Commissioner Dance.
yes.
Saying it passes, item number 4 passes, or we're just really not a. Let's go ahead and go to item number 5, discussion and direction on initiation of the conflict resolution procedures provided by the Florida Governmental Conflict Resolution Act, Chapter 164. This is pursuant to the Flagler Beach annexation that was adopted on February 26, 2026. I'll look to you, Mr. Rodriguez, to have an initial discussion.
Excuse me, okay. Based on the last county commission meeting, you've asked to bring the matter back that you want, the commission and open body wanted to discuss whether or not to undertake another Chapter 164 proceedings involving the recent resolution, recent ordinance adopting the annexation of the project commonly known as Veranda Bay. So what the purpose of this meeting is for you to discuss whether or not this is an issue that the county wants to undertake. I have prepared a draft resolution if that is the course of action. I think it's important to note that at least in regards to the drafting of the draft resolution is not that is the recommendation of the county attorney's office to undertake that. That's just been prepared so that you would see what the effect of your discussion would be. This is to distinguish it from the last 164 action, because now we are kind of beyond that one. We are beyond the first order of first proceedings we undertook. So one of the things you guys wanted to discuss is, well, what is the effect of undertaking this second round of discussions? What would differentiate this one from the first round? So I'll give you to distinguish it from the first challenge, and then you can discuss I'll kind of separate it into what are the legal issues, but then what would be the effects of undertaking this proceeding. So what would differentiate undertaking 164 proceedings this to go around from the last one is that the last one's really focused on a comprehensive plan amendment because there was no legal challenge to the annexation. This one would be strictly challenging the annexation because there's only one issue that would be discussed and brought forth in the conflict resolution proceedings, and that would be the propriety of the annexation petition itself, and whether or not the city of Flagler Beach followed Chapter 171, namely in the receipt of the petitions for annexation. The county has raised that issue both at the city's Planning and Zoning Board as well as the city's first reading on the ordinance, that the signatures for the annexation were improper because the petition did not contain, as the statute states out, the signatures of every single of the property owners seeking to be annexed. And it is widely held that the city's position is that that was met due to the language in the Declaration of Covenants for Veranda Bay, which states that the declarant, in this case it would be the developer or the developer's successor in interest, has the right to annex the properties into, and the language in the declaration is that the developer has the right to annex the properties into any jurisdiction. Actually, the language says into Palm Coast, Flagler Beach, or any other jurisdiction, be it a county, which theoretically I don't know how they could go into another county unless another county were to form, or any other special district, without the consent of the property owners. So what it means is that the developer can go and take the annexation, and they do not require the consent of the property owner. With the argument being that when the property owner purchased the property, they purchased with the knowledge of the declaration, their deed subject to the declaration, and therefore they don't need to give the developer the consent to annex. They've already done so by virtue of that. Then it becomes now a legal argument whether that meets the requirement of 171, especially in line with the Attorney General's opinion, which was attached in your packet. In that case, that was an annexation of a condominium association in which the board members of the condominium signed the petition, and the Attorney General's office stated, well, when you interpret the statute and annexation statutes, the annexation statute is to be interpreted very narrowly. It is the wording is the wording is the wording. And because the wording of the statute says every property owner has to sign the petition, that means every property owner, and that you cannot delegate that forward, being you can't have a representative sign for everyone. You needed to have the every owner. It is important to note that the matter has not been litigated, so no court in Florida has ruled on that issue of basically statutory interpretation. So the Attorney General's opinion is only persuasive. It is not binding on the courts of Florida, and it is true that no court has ruled on this matter. So should you elect to proceed to go forward with such a challenge, this would be the first legal, and it proceed forward to a decision. It would be the first decision on this basis. Another differentiation between a potential challenge under this route than the last one. The last one, we were worried about that statute of limitations and that 30-day window that we needed to seek a extension or an agreement with the city. This one's different because under 171, there is a specific clause that when it's a local government that is actually challenging the annexation and is going to challenge the propriety of an annexation, it actually says it must undertake a 164 review. Then, after the 164 review is complete, then you have 30 days after the completion of the 164 proceedings to file your petition for writ of certiorari. So what that means is this is actually not a lawsuit in the sense, this is actually an appeal of the decision. This is going to be heard by the appellate division of the circuit court. So there's already kind of a time tolling within the statute within 171 because it's a local government who's challenging the annexation. So that's already built in. So there's no concern about that in regards to doing such a challenge in this aspect. One important thing to note is that any type of the challenge based on the language in 171 is that it does contain an prevailing party attorney's fees clause. So theoretically, if the county were to lose the challenge, the county would be paying the city's attorney's fees and vice versa. So that is to limit to what the legal parameters of the case. As it is with any case, anytime you're going to decide to enter a case, you begin to determine what are going to be the long-term effects or even the long-term goals of the county in seeking such an action. It has been stated that the city has stated and the developer has stated, well, if there is going to be a challenge on the petitions, I can't verify whether this will be an action or not, but it has been stated, well, then there is and I don't want to use the word threat, but it has been noted that, well, then the application can then be revised and they'll just pull the platted lots that are listed in the plats of Veranda Bay Phase 1A and 2A from the application, and therefore then the annexation would consist of those developer-owned or developer-controlled lots, and they would proceed forward. Then the issue of the signatures becomes moot, because you have the one owner who has control, and it would move forward. That could proceed forward. Then any 171 challenge, there doesn't become a challenge. That would depend, the issues then would depend on what that would look like, how much of the developer-controlled properties go in or get pulled or not. In the event that if too many are pulled out, is an enclave created? But that's all up to speculation without knowing what's going to be the final results of what that annexation is going to look like. There may be some developer-controlled areas that will get pulled out of the annexation in order to avoid there being an enclave. Then that also then would trigger another aspect of this issue. If certain areas are pulled out, there has been some thought that then, well, does that then bring the amount of property that's going to be annexed into the city fall below that 5% threshold that would require the supermajority vote of the city council? The developer could maneuver those areas to what is going to be pulled out or kept in as part of the annexation to have those percentages fall below the 5% threshold, and therefore then not require a supermajority vote of the city. There's all sorts of machinations that this commission needs to weigh. Also, one of the things that you as a board need to weigh is the current pending agreement that the county has with the developer in regards to the tentative, what we've called a contribution costs for the impacts on John Anderson Highway as part of our settlement in the first 164 action, in addition to the acreage for the preservation is in regards to Summertown. I know there have been rumblings that there could be that undertaking this action would cause that agreement to basically fall apart. And one of the things we would need to weigh, and it's for you guys to weigh and discuss, is the impacts that the county would be weighing in regards to the annexation of both Summertown and Veranda Bay, in taking into account those the financial contribution that we sought and negotiated as part of the agreement for the maintenance of John Anderson Highway and its impacts on hurricane evacuation, in creating a fund that was going to be collected as part of every building permit that was applied for Summertown. The agreement also included that was going to include every building permit in those portions of Veranda Bay that were set to be developed as well. So we were already taking into account the Veranda Bay development for John Anderson Highway. Those lots that are already part of Veranda Bay, those are already vested and grandfathered in, and namely because the county has already taken those into account because those were platted in the county, and so those lots, the impacts on John Anderson Highway that those lots have already been taken into account as part of its approval at the county level. So the question then becomes, if that agreement falls apart, then they reconfigure their annexation to exclude the existing Veranda Bay lots and then go forward with a new annexation, there's going to be development, but now we've lost the ability to get a financial contribution from those new lots to help maintain John Anderson Highway. So have we kind of cut off our nose to spite our face? That's something you would have to weigh as well. And so those are the things I want you to take into consideration and discuss. And I think that was the intent, that you wanted to have this meeting to discuss those issues before whether or not you would wish to undertake opening a second 164 matter in regards to the annexation. I want to make it important to note that if you decide not to proceed forward with a 164 conflict resolution proceedings in this case, this will not preclude you, or will not create a precedent in a future matter against another future city or even Flagler Beach in the future from doing this. You're not establishing a precedent. You have the discretion as to whether or not this is one case you wish to go forward or not. So if the instance comes forward again, this will not preclude you from weighing an option, weighing whether or not there's a valid case to go forward on a matter. So if you elect not to do so, this will not preclude you from in the future reweighing issues similar to this and going forward. You're not establishing a legal precedent that'll bind you forever to not undertake such an action again because you've elected not to do so in this matter.
Yes, sir.
I think there's really only one question here, and the lawyers will have to tell me, but it seems to me that my reading of this is people, when they buy a lot in Veranda Bay, they have signed a document that said they agree to annexation. And if I'm wrong on that, I need to be corrected. But if that's the case, then the only remaining issue would be the vacant lots that haven't been built on yet or been bought. And those lots can be signed en masse, I believe, by the developer. So if that's the case, then this whole discussion is moot. That we should just say, okay, done deal. Everybody's signed. Everybody's agreed to the annexation. So Flagler Beach should move forward with the annexation. But I need that question answered. Have they, in fact, signed a document that said they approve of annexation when they bought the property? I need an answer to that question.
I'll wait before I say anything. Would you like to speak first? I have some questions.
I don't have any questions. I think my position is pretty much out there. I will say that, and thank you, Mr. Rodriguez, for bringing to our attention that there is already good faith negotiations done on the contribution and the purchase of the land. I don't see the two tied together. I did see, Mr. Rodriguez, did I see Veranda Bay in the agreement that Mr. Chimento sent over? But that was as it pertained to the John Anderson Highway. It was only part of the Veranda Bay in that agreement was the part that talks about the impact on John Anderson Highway.
Correct. That's the only thing we did weigh on was because the first 164 proceedings, the issue was our comp plan and the impacts on John Anderson Highway because of the increase in density in that area as a high coastal hazard area, and that any increase in density in that area, we as a county had to take into consideration any impacts that would affect that highway as a hurricane evacuation. Then the agreement encompassed Veranda Bay because that was going to be an end result of an increase in density. So that's the only, yes, the scope, Veranda Bay and Summertown were both kind of joined in as an increase in density, and that only related to its impact on John Anderson Highway.
Thank you. And my understanding of the signature, when you sell a vacant lot, in the state of Florida, there's an addendum to the vacant lot contract that talks about the homeowners association, the developer, to my knowledge, unless they were able to produce it, which after several attempts, they haven't. I believe the document they're talking about is the addendum to the vacant lot that spells out that the person that's buying the lot understands the covenants and restrictions. I don't think it says they agree to annexation, and it surely, the signatures are surely, and it's part of our packet, they're surely not on the application that was presented to the state. So I agree, it's probably a gray area or splitting hairs, but the signatures is the issue, at least for me, and when the annexation takes place, or it already has taken place, are the people that are being impacted, are they signing off on it? I think that's the spirit of the chapter, the opinion from the Attorney General. You stated that this is more on a legal side than the last one. Is there a time frame to get an AG opinion on something as specific as this, or does that have to be more broad?
When it comes to time frame, the Attorney General's opinion will still not be binding. It will not be binding on the city. It will not be binding on the county. It'll still be persuasive. It's not binding law. So would we be able to use that opinion to be additional persuasive authority on a court? Most likely. Time-wise, though, we would not receive the opinion from the Attorney General's office prior to the expiration of the 30 days from the date from, we would not be getting an opinion from the Attorney General's office prior to March 26. That would be for starters. And then again, still, it's just an Attorney General's opinion. It's persuasive authority. It's not binding. So that's...
And again, not that this board has any reason to, no, I don't want to use the word worry, but as far as Flagler Beach is concerned, and as far as a carve-out of the 150-something lot owners right now, the Flagler Beach financial impact study states that both Veranda Bay and Summertown have to be part of the study in order to make this a financially feasible project. So carving it out at this point is probably not fair to Flagler Beach, but you know, that's between them and the developer. Their studies and all their paperwork, whatever, says that both parts are needed for the actual city to benefit from the annexation. That's all I have right now.
I have a question. It might be for Mr. Smith as in the audience. I don't know if you'd like to come up, sir, and I can ask a couple of them because it's specific for Flagler Beach. Hey, good morning. Could you state your name?
Yes, ma'am. Drew Smith, City of Flagler Beach, City Attorney.
Thank you for coming, sir. Quick question. I know that it says in our group that the city and developer took the position that the master declaration of covenants, conditions, restrictions, and easements for Veranda Bay satisfied the requirement of the statute. I have not seen anything, but did the city of Flagler Beach receive individual signatures of anything that pertained to the covenants and restrictions?
The position is a little bit different than that. And I think everybody here is aware of how declaration of covenants and restrictions work.
Yes.
When you purchase the property, usually it is in
Run
the
with the
HOA
land.
context. Yes, we
Yep.
sign the deed. All the rights we've given, those are given away. All the rights we've received, those are received the minute we sign that deed. So it's not the question of was every signature provided to the city. It's once that deed was signed, once those declarations were active, once that declaration that said developer has the right to decide, that it's developer's signature. That at that point, it's the developer's signature that controls because developer holds the right pursuant to that declaration.
Okay. Okay. Can we pull up, oh, sorry, go ahead.
Can you answer the question?
That
Do
you asked earlier?
No.
Yes.
Yeah, that I asked earlier. You're comfortable or not comfortable that
That is the city's position.
that they have?
In accepting the annexation, that is the
They've
finding.
accepted annexation.
Correct, in accepting the annexation, that it's developer signature that controls, because that declaration, that the minute those individual owners signed the deed, they gave that right to decide that fact to developer.
And so the city, if there should be a legal challenge, it would be on the city, correct, and not the county from those residents? Or it would be on the
Oh,
developer?
absolutely.
Right,
It would be,
on
it would be
you.
the same challenge that you're talking about right now.
Okay. Okay. Does anybody have any questions for Mr. Smith while he's up? No? No? Okay, thank you, sir.
Thank you.
Thank you. I don't know, so to me, this is difficult because I really believe in the plain meaning of that statute and interpreting it, and it talks about individual signatures, so it is difficult, and since there's no case law, I think it makes it complex to make a decision on this for me. I would have preferred maybe to do some sort of tolling agreement with Flagler Beach and see what they could provide. Either the developer could provide individually signatures or the AGO letter on this matter, but it sounds to me like we wouldn't know for sure if the AGO would pick up the matter to look at to begin with.
No, well, I think the current procedures for even requesting an attorney general's opinion, I would actually need a vote from
Yes, that's
you
correct.
guys to actually
that.
authorize me to seek an opinion from the attorney general's office, and then prepare such an opinion and then wait for it to come. It would not. I'm pretty confident that would not come back in a timely manner. And again, what would come back from the Attorney General's office still is persuasive and not binding on either of us. It would not be binding on us. If it were in our favor, it still wouldn't be binding on the city. If it were in the city's
I understand
favor,
that.
it would not be binding. And there are still questions of law, and but at the end of the day, I think the question is this the case that we want to go up that hill to fight? That's up to you guys to
No, but
decide.
I
Is this
will
the
say
case you want
this,
to?
regardless of how this goes, I almost feel like this is one of those AGO letters we should get for the state of Florida out there on this topic. Because I've read through all the annexation back to 1976 AGO letters, and it's talked about, but not, there's nothing real specific about the signature in those. There are AGO letters that talk about plain meaning, ordinary common wording, take it to mean what it says. That does exist out there, but I feel like regardless of the board's decision, I'm wondering if that could be an AGO letter we send for, regardless of our decision on this matter, just to have, because we're going to have other annexation at some point, but.
That's your prerogative.
Yeah, I understand. So I bring it back to you guys. Do you, any more discussion before we go out for public comment? Go ahead,
Yeah.
Mr.
Carlos, do you have those pictures that you could put on the screens? I was fortunate to get a couple pictures from the Bulow Ruins State Park Ranger, who traverses the creek all the time, and he went up to show the other one, if you could. It's going to be hard to see at this scale, but this is the headwaters within a week, 2 weeks ago. And I think the glaring thing that you see here is the clarity of the water. This is like spring water at the headwaters of the creek. And the other picture that he sent me was of an osprey nest that's there. And I think we'd be naive to not think that taking action, 164 action, doesn't affect the negotiations that we have worked out with the developer at this point. And as you make your decision, this is what we are jeopardizing, in my opinion. And we've worked too hard to get to this point to where we are pursuing preservation that affects the pristine quality of the headwaters. And just wanted to give this to you as you base your decision. Thank you.
May I ask a question? Commissioner, you were part of the negotiations, Did you walk away from there feeling that it was a all-out negotiated deal, or did you walk away from there thinking that this could be jeopardized at any time if the board took any type of action at all regarding the annexation of the other side of John Anderson? And we can't separate the two issues, Commissioner. We have to take into account, we don't even have a binding number. We don't have anything that states that this is going to happen as of today. So you're asking us to vote or to think about giving this up in order to take no action. Is that what you're saying?
I'm saying that the agreement is based on good faith negotiations with the developer moving forward. They are going to work with us in whatever capacity we need them to secure this, even outside of the Florida Forever. That's the one path we have right now. That may not be the permanent path. State can't even figure out how to fund Florida Forever right now, so that's a whole separate issue. But I would think, again, my comment is, you'd be naive not to think that pushing 164 doesn't affect the future cooperation with the developer on this. And
Well, that's a sad day in Flagler County then.
this is what's in front of us. You make the decision.
That's not true. That's called quid pro quo. It is right in front of us. And it's not the way we do, it should not be the way we do deals in Flagler County. So this deal was made, I think you're right. I think the funding source is a bigger challenge right now than whether or not we can get this done in 3 years. But the developer in this situation has flaunted his environmental protection policy and the way he makes decisions, and this should never come between us looking out for the betterment of the east side or Veranda Bay versus Bulow Creek. And that's a sad day in Flagler County for us.
Well, I think the other bigger argument is what Commissioner Hanson said, is this is an issue between the property owner, the developer, and ultimately the city of Flagler Beach. You heard from the city attorney, that is the legal opinion of the city attorney that is determined that their process is legal. I think pursuing, and this is the part that I'm getting at, pursuing an avenue that is speculative. It's not a slam dunk that anything that we pursue with 164 is going to result in a victory or result in us having to pay attorney's fees or further occupy the time of our attorney when the city of Flagler Beach has made the determination by their legal staff that they are satisfied with it. It is not a position the county should be in. And by doing that, you further alienate the developer on ongoing negotiations. We should back out and let the city of Flagler Beach take care of this. I mean, really, we continue to further disenfranchise the city of Flagler Beach and our relationship with them pursuing this. I don't think that there's a lot of wins at this point for us, and that they have other options to pursue. One, if we do go down 164, they have other options to pursue to complete their mission. And then we have further disenfranchised the city of Flagler Beach. And I mean, there's a lot of dominoes to this, just pointing out the different dominoes. You make your decision based on the information presented.
And we did have, our attorneys did make a judgment on this back in March of 2025, when both Mr. Hadid and Mr. Moylan, at our direction, brought us to a protocol on how we evaluate annexations. And this was at the direction of this entire board. And the first thing under procedures for voluntary annexations states, all property owners in area to be annexed sign a petition. So they come to us with the intent to annex. It's our job to look at the, in this case, voluntary annexation. And I think that's what got us, I know that is what got me to this point.
And the city of Flagler Beach gave a very valid rationalization on that process. So I don't know why we continue.
Okay.
Yeah, I agree. It's moot. I mean, I don't know what we're deciding here. Their lawyer and their commission say they have met the legal requirements. I don't want to go in front of a judge and say they aren't doing their job, because it looks to me like they have done their job.
I just have one question, and I'm going to address it to Commissioner Dance. On this waterway, is it going to change the quality of life there?
I don't know that I understand your question.
Well, you're showing the clear waters. The water was, like almost like a spring. So will that development cause danger to that area?
Yeah, in effect, we're pushing the boundary, the buffer from within 200 feet, right? You can't get closer than 200 feet currently with the way the agreement within the planned unit development is to the center line of the creek. That's the closest they could get. We're pushing that boundary about 2,000 feet away from the creek. We're preserving 150 acres that are the closest area to the headwaters. We move that development boundary farther away from the creek. So any nutrient leaching, which is common in developments because of grasses and fertilization, is moved significantly farther, and it allows the floodplain to effectively do what it does by nature, which is filter runoff and protect the drainage patterns of that area.
Okay, thank you.
Any
Also,
other? Oh, go ahead.
I have one other thought, and this is just my thought. I'm going to ask to Mr. Rodriguez. Is there any guarantee that we will receive the funds to keep in this agreement to keep our roads, John Anderson, in a healthier, whatever they need to do for traffic and exits and emergency space?
Well, if the agreement is, and if we enter into the agreement and you, which the agreement is slated to be on the agenda for the next county commission meeting, and it is approved, it becomes a contract. It's a binding contract between the developer and the county, in which once we determine what that amount is, which is going to be the overall contribution, and that's just it's determined usually through traffic studies, and you come up with what is going to be your proportionate fair share of the impact your development, your density creates on the road, and that's taken into kind of consideration with all the other developments around. So this is, my percentage of the impact is X. We take that amount, that's divided up over an amount of time, and then as each building permit is applied for, they pay a certain amount. It's almost an impact fee that gets paid, and we retain that into a fund that's to be used for that. So yes, it becomes contractual and it's enforced by contract.
Okay, thank you.
Good. Okay, so from what I've gathered here, that Mr. Smith spoke on behalf of Flagler Beach, that they believe that this developer's signature is sufficient, given the declaration of covenants and conditions. We've heard from Mr. Dance talk about the agreement on Bulow. I'd certainly hope that Mr. Belchi, regardless of what happens here today, would consider that it's in the best interest of Flagler County residents that they place that property into conservation. I'm going to go ahead and, before we take a motion, I'd like to go out to public comment, if that's okay with you. I'm going to open up this item, number 5, for public comment regarding the Flagler Beach annexation and the discussion on it, on the Conflict Resolution Act. Those approaching, please say your name. You have 3 minutes and direct your comments to Chair. Good morning,
Madam
sir.
Chair, Commissioners, I'm John Tanner on behalf of the nonprofit Preserve Flagler Beach and Beulah Creek, Inc. I think first I would like to go to Mr. Hanson's question is, what does this statute really say? And the poll star, the beginning place in Florida for interpretation of statutes is a plain meaning of the words. That's pretty straightforward, and that's the law in the state of Florida, basically. And there are other criteria that may be, for instance, context, et cetera, that may be considered in trying to interpret a statute. In this case, there's no ambiguity. All over the state of Florida, when Chapter 171 was passed, the various counties were having their way. Everyone was doing their own thing with regard to annexation. So the Florida legislature cured that, and they came up with one way and one way only, and that annexation process is set forth in 171. And in 171, it says that virtually every owner of property must sign. There's no ambiguity there. It doesn't say can agree to a restriction or a covenant. A restriction or a covenant is not a petition. It said they must sign a petition. It doesn't say just sign a document mixed in with other closing documents, and by the way, it appears to just let the developer do whatever he wants. It doesn't say that the property owner agrees to that at all. All it says is he can do it. They're not giving him permission. What they're saying is they're not going to object to it. There's a great difference in not objecting to something and supporting it. In this case, the people bought this property believing it was county. In fact, it was and still is county. There's a great difference in being under the governance of the county or the city of Flagler Beach, beginning with taxes, utilities, regulations, etc. These are Flagler County citizens that are being annexed, and they have no voice in it at all. In fact, this is really the poll star of cases. This is one vote, and that's the owner of the property, Mr. Allen, through his corporation. One vote, and he simply says, I'm signing a petition, and the heck with the law that requires every single owner of the properties in that area being annexed must sign. That's to protect them. These people didn't sign up to join the city of Flagler Beach. They bought property in the county. And there's a great difference in being under the governance of the county and the governance of the city. So you have harm to county citizens right off the bat. The language is clear. The fact that they're trying to substitute a covenant or a restriction for a petition is ludicrous. It doesn't say petition. It doesn't say anything. It doesn't say covenant or restriction. It says petition. There are no signatures on the petitions. If the developer wants to go back and get the signatures of all of the people that own the property, let him do it. And if all of the people that own property in the development petition to be annexed, then let it be annexed. But until they follow the process that this state has established, they're violating the law. This would be an illegal annexation.
Thank you, sir. Anyone else? I see several. Good morning, Mr. Belchie.
Good morning, Chair. I'm Ken Belchie. I am here today representing Palm Coast Intracoastal LLC, Miranda Bay Investments LLC, and Sunbelt Land Management LLC. So I would respectfully request additional time, if I may, since I'm representing 3 different entities.
Okay, it'll be 5 minutes.
Thank you very much. Last week, when this issue arose here at this commission, I was immediately contacted by a number of people, 3 actually, who said, Ken, if I were you, I would just back out of my agreement that you did 2 weeks ago, 3 weeks ago, And now you don't have to give the additional time on the ESL, and now you don't have to impose the transportation impact fee for the land for the county. And I emphatically said, no, I will not do that. And I'm telling you here today, I will not do that because we have a deal. I was in a room full of people, including Mr. Dance, where we hammered out an agreement to where we would impose an impact fee. I would give additional time on the ESL, and I will not back out of that agreement. I want to state that right here today. It would be unreasonable, it would be unfair on my part, and it would be, I feel, unethical on my part to do that. So I will not do that. But I do want to address something here about what's come up. This issue with the signatures, in my opinion, we looked into this prior to going through this process. I was insured by not just Mr. Scimento's office, but additional attorneys, including Mr. Smith, that this was legal, that we could do this. And the fact that there is no legal case that supports it does not mean it's illegal. In fact, that's comforting to me. No one has ever challenged this before because their attorneys probably told them there's no sense in challenging it because you'll lose. And I think they would lose now. So I'm not worried about that. And I have, in fact, publicly said that I would indemnify the city of Flagler Beach on their legal expenses if this comes up. So Mr. Smith is comfortable with it. He's the one that really, well, ultimately it's the city commission that has to make the decision, and they made that decision. They're comfortable with it. But what would happen if this were to change? I believe that simply the city of Flagler Beach would come back and they would carve out those 122 lots, which is what it is. The rest of the annexation would move forward because we would still be contiguous to the city of Flagler Beach. And who would lose in this case? It would simply be the city of Flagler Beach. They're still going to provide water and sewer. They'll likely be asked to provide fire and police protection. And they get no ad valorem tax revenue from it. So the city of Flagler Beach and its citizens are the one that lose in this case. And I'm not sure why this commission would want to do that. Again, it's a city of Flagler Beach issue, and they have agreed that they will defend that if called upon to do that. Now, these kind of issues have impacts, and I want to tell you about one right now. I am working on a deal with a major development company that they have agreed verbally with me to do a deal on Summertown that will change the retail and commercial landscape of that area forever. It's a great, great deal. And it would really expand the retail opportunities, the dining opportunities of that area over there for the citizens. Now, I'm under an NDA and I can't disclose who it is, but I know there's somebody probably here that would scoff that, well, you're going to say you have a deal and, but you can't tell us who it is. I've asked Cornelia Manfrey to come today to back up the fact that we are working on that deal that would be very significant, not only for tax base, but also for jobs. They told me that it should create 150 full-time jobs and additional part-time jobs. Now, I know that's not enough to completely make up for Boston Whaler, but it's a good start. So that's what's at stake. They told me, though, they said, we cannot and will not get involved in this and sign on the dotted line until you resolve all these issues with the county. We don't want to get involved in that. I don't blame them, but that is what's standing in our way. And I have, again, Cornelia Manfrey here to back up the fact that negotiation is happening and we're this close. So there's a lot to be said about these kinds of issues that come up. People watch from outside. They watch YouTube. They watch everything that's going on. They know about these controversies. I would ask you today, we made a deal where we said that we would give that additional time, and we would give up or we'd add the transportation impact fee, and that was supposed to be Mr. Rodriguez's words, not mine, a universal settlement that would take care of all of these issues, including anything related to the annexation of Veranda Bay. That was the deal we made.
Thank you, sir. Good morning.
Good morning, Team Flagler. How are you? Cornelia Downing Manfrey. Yes, Mr. Belshey has asked me to be here because I have for years been looking for commercial properties to bring companies in here to bring jobs. We are all about our economic development. We must build our commercial base now. We may run into an economic turmoil. Where's the money coming from? But from the houses. We must build our commercial base. So for some time, about a year ago, I was approached by a national company to find a property here in Palm Coast that would be suitable for the type of development that they'd like to bring in. I called Mr. Belshey, knowing that when Bobby Ginn had the property, there was 600,000 square feet approved for commercial for the future. This has been there, this has been planned, now it's time to execute. So Team Flagler, I ask you this, do you want economic development? Do you want us to bring jobs in? Because that's what we have with a gentleman's handshake right now. 150 jobs for just one of the buildings. I'm bringing more. I'm with One Sotheby's International Realty. I'm working with a company from France, Italy, and now another company from Puerto Rico. They like Flagler County. This land gives us opportunity to bring that commercial development in. So we also have an image here. When something is prohibited, don't do it. If it's not listed as a prohibition, it's permitted. You're dealing with something else here. It's paperwork. I have been a member of Grand Haven for decades. When I bought my property there, I signed on the dotted line, having read the big book of all the restrictions. I knew what I was signing into. Ditto for this. This is not a single lot out anywhere in Palm Coast. This was a subdivision that was planned and approved, and when people bought their lots in that community, that's what they understood, what was inside those documents. So I ask you, with 135,000 people in the county, that's who you're responsible to. I don't want to take another dollar from my pocket to pay for excess legal fees on lawsuits that don't need to be had. I am asking you, you are Team Flagler, you are the problem solvers. Let's get this moving. Let's bring these companies in here, establish a stronger tax base, and look for the beauty of cooperation between municipalities. Thank you.
Thank you. Good morning.
Good morning, everyone. My name is Sandra Netubik, and I live at 112 Pine Tree Street, Flagler Beach. Number one, I just want to say this real quick to Mr. Belchey. We are not losers in Flagler Beach. We will be winners. I'm going to read you something that I wrote. I was going to send it to you, and I decided to come today. I said, I am only one individual person. I have lived here since 2000. My parents lived here for over 38 years. They're now both gone. And it is a city and a county of many great values, residents, and who love what we used to call the old fisherman town. The annexation of Veranda Bay has been a problem from the beginning. It includes Veranda Bay, it includes the Summertown, John Anderson Highway, our waterways facility, and a lot of that is all mixed in together. I am a victim of Veranda Bay where I live. I have seen what they do, and let me tell you, it's not fun. I would like to thank Representative Richardson for saying that she felt like that people, you all were here to represent all of the county and the people. And I wanted her to know I really did appreciate that. That made me feel good to know that my commissioners are working for us. But I would like to also say to as far as Mr. Belchy goes, I don't trust him, and I feel like he always leaves the door open to change at any time. There is no really set deal. I also realize that a lot of this is Flagler Beach's problem. Flagler Beach brought it on themselves. They did not follow all the proper state rules and regulations. The resident petition issue for Veranda Bay for the annexation has been a problem all along. And I would like to see the annex petition follow the proper state law to do what our representative of our state has asked us to do. I would do it. I would never sign a petition as whatever. But anyway, I also want to thank Kim Carney for her bringing this forward and looking into it and helping to find the right answer and to go forward. And I really hope that you all will do the right thing for the people of Flagler County and Flagler Beach. Thank you.
Thank you.
Raymond Royer, Painters Hill, as a candidate for County Commission, District 2. As I go get my petitions, I'm going to say it again, people are not upset with homes being built. They just want more sensible development. They continue to stress to me they are disgusted by these developers coming in at free will and use this blanketly, give them what they want. Shame on Flagler Beach, but we just had an election, and it seems like a young man just got elected, and the old guard is gone, and I'd like to see what this young man's going to do, and I think he's going to discuss the same topic. Also, in regard to these deeds, it's a shame that you're not following the statutes and the deeds that these people were granted, that they should have signatures, and they didn't get them. My question would be to the developer. I didn't hear him say that he even approached to get these signatures, and probably if he did, he found out the majority were not going to sign off. So he's going around about trying to get property owners to get these signatures on his development. And just like it was discussed earlier, yes, a developer comes in, his one vote, yes, he's got to get property owners to sign covenants and deeds for this new HOA. Yeah, that's normal procedure, but the developer coming in there and bringing a strip mall in a residential area, the young lady just mentioning, she's bringing jobs. Well, I sit on the public side for affordable housing, and we have a problem with affordable housing. And I guarantee that none of these jobs are paying a minimum of $38 an hour. So if we're going to continue paying $15 minimum wage, we're just going to continue with affordable housing issues. So I would question bringing jobs in. I was not happy when you voted on that structure for the airport neither, because when I did look it up and see the lease agreement for the property that you're given this building to be on, it was unbelievable. I mean, what a deal. I could see why he's going to quickly want to build a second one, because he's got a good value for that lease agreement. I mean, you just basically gave county property away, so again, the election's coming up, and I think there's going to be a change in the county direction moving forward, just like Flagler Beach is changing, because you guys are just giving everything away cheap and making deals behind back doors, and then this is where we are today. Thank you.
Thank you, sir. Anyone else? Mr. Bellhumer?
Yeah, Rick Bellhumer, still Flagler Beach City Commissioner. until Thursday anyway. One of the first things that I learned by attending meetings, both in the county and the city, was the struggle for finding new revenue. And you all are acquainted with that as well. Here we have a chance to finally, pretty much a last chance at annexation to create new revenue for our city. And we have our own representative fighting us. And not only are you hurting the taxpayers in Flagler Beach by minimizing the dollars that we could get to use to repair infrastructure on the island, but you're also hurting yourselves by he wants to build a commercial component on the Veranda Bay side. So guess what? Yes, you guys are collecting money on the houses that are already there, but the part that you guys didn't permit already has not been set yet. So when that becomes commercial property, that will raise your revenue. So I just don't get the logic.
Thank you, sir.
Good morning. Michael Schmenta for the applicant. I think it's obvious that we are about to take a vote that could have a significant impact on not only this development, but your all's future. I draw your attention to Section 5 of the agreement that was put forth by your staff and the developer about the roadway impact. And it was always intended that by executing that agreement, that would resolve all disputes related to Veranda Bay, because it lays in there Veranda Bay annexation, Veranda Bay comp plan, and Veranda Bay PUD. And for you, Ms. Pennington, and for you, Ms. Richardson, who we hope to get your vote to not pursue this, is that you might want to ask your staff, your administrator, your Adam Mengel, your Mr. Dance, your Mr. Richardson, is what was intended by that very agreement that was put forth by your staff and the developer. So with that being said, I just get to what my dad taught me, start with the end in mind, and that is, what is it that you want to achieve by considering this 164 action? Obviously, and I say this with due respect to Ms. Carney, is that she is against the development. She has been against the development for many, many years. And this may be what is perceived to be a last-ditch effort to have a finger in the soup to spoil this development. Mr. Tanner is very obvious that he is against the development. He has been so for 10 years or 5 years. And so I don't think that's what you two are out to achieve. So I ask you, what is the goal by moving forward with this 164 proceeding, other than by some others to win the battle? If it is about proving what the law is, that should be declared. But I think your attorneys have expressed to you that this is a novel approach or a novel situation in the law that has not been litigated. And why should the county waste taxpayers to prove a point that gets them nowhere further down the road than what you were intended to achieve, is the benefit of the community? And by delaying this, maybe you get 121 lots removed, maybe you don't, we don't know. But it doesn't change the end goal, that this development is going to happen. This development will proceed whether or not those 121 lots are there. So even if you were to champion 121 lots in or out, it doesn't change the goal. It doesn't change the finale, that Summertown and Veranda Bay will be developed. Summertown and Veranda Bay will be for the benefit of Flagler Beach, and only by removing it, you will cost Flagler Beach at build-out, those 121 lots, approximately $800,000 a year in ad valorem revenue to those residents, frustrating Flagler Beach's financial position. So I'm asking you specifically, ladies, to not go through with this, because it doesn't mean anything. Thank you.
Thank you. Anyone else wishing to speak? No, sir. Yes, sir.
Jay Gardner, Flagler Beach resident. How many of the people on the 121 lots are in the room today complaining about it? Just curious. When you bought in there, you knew that you agreed to something. This isn't sneaking up on anybody. In other words, they bought and were told, these restrictions are on you. It'd be like you saying you want to build a 1,500 square foot house and there's a 2,000 square foot minimum. You bought knowing you had to do that. So I don't think that's the issue. And the fact that we don't have 120-something people waving their fingers at us, I don't think it's appropriate for our commission to step on the city of Flagler Beach where they've looked at this and worried about it. And it is a benefit to our city. And this isn't about us stopping this development. The lots we're arguing about today are already there. They're approved by this board and they're being built on. So we're not ending this development. That's been my argument about it the whole time. Flagler Beach needs to take advantage of this. We are done annexing. There's no more land available to us. In our water treatment plant, we are going to get our affluent treated and put it in this subdivision instead of dumping it in the intercoastal waterway, which we do right now. That is a gift to us. And we have to do this whether or not they build this subdivision. We're not incurring this 40-something million because they're coming. It's going to help us. And the impact fees and all those things that we're going to benefit from in Flagler Beach are very important. And of course, the county is getting some things, as Mr. Dance has pointed out. We're going to benefit from all the things with our headwaters and all that. They've done everything they could do to help us. I give them credit, and I give the Flagler Beach commissioners credit for having the foresight to see past the people that are just against growth and to take this project. Please don't continue beating on this. It doesn't make any sense to me. Thank you.
Thank you. Anyone else wishing to approach? You've already had your 3 minutes, sir. Oh, sir.
I have 2 minutes.
No, sir. I think we're going to close it up, right? Are you representing Bulow?
Yes, ma'am.
As their attorney? Okay. I'll give you the 2 minutes for the Bulow.
This is not a one.
State your name, sir, one more time.
My name's
Apologies.
John Tanner, individually as a resident of Flagler County. This is not just a one Attorney General opinion. The Constitution of the state of Florida requires that annexation only be as provided by law. That's Chapter 171. That's the state constitution. The Attorney General opinion cited by your attorney, 8122, says the only annexation process and procedure is under 171. And finally, AG 77-133, cited by your counsel, also says municipalities are prohibited from creating their own way to annex. That's what the city has done in this case. They've created a different route. They said, we don't need a petition. We've got someone that has a restriction and covenant that they signed. That's not a petition. That violates the law. It's an illegal annexation. And finally, we have this concept out there that more people means lower taxes, a bigger tax base, right? It's never happened in the history of man that more people are less expensive. The services it takes to keep them going far exceeds basically what comes in taxes. All of us know that. And we have that, they said there's no case on this. The reason there's no case, the language is clear. It says the property owners must sign a petition. There is no petition signed by the property owners. It's an illegal annexation. They can go back and do it right. Perhaps Perhaps they didn't do it right because they didn't believe they could get the people to sign it. Is this a bait and switch? You know, here you are in the county, now you're annexed. This developer knew he was going to annex all along, and he could have put the petition in the papers. He didn't put it there because it wouldn't have passed. Thank you.
Thank you, sir. Any other comments on this topic? If not, I'm going to bring it back, close the comment. I have just a couple comments myself before we discuss it further. One, I got a little lost in the weeds there because if the commercial is coming in at Summertown, well, Summertown is a done deal from my perspective. So I don't want to muddy the water with that thought because the people will still be there whether they're in the county or the city. So anyways, I just don't want to muddy the commercial piece of that. I'm grateful to you, Mr. Belchie, that you're able to find commercial to come into the area. We're always hopeful for that. I do want to say this, regardless of the decision or the motion that we get up here today, I would like the board to consider getting an AGO opinion on this regardless, because there are people in that area that may choose to use the AGO at some point to further their cause with lawsuits or with being annexed. Irregardless, it would be nice to have an AGO opinion on this for every other place. I'm sure we're not the only county dealing with annexation. So if there's a motion made, I would like to see it include an AGO letter on this matter, on petition versus individual petition signatures versus, I believe it's what I read the restriction that he has in the covenants and restrictions. I don't know what the wording should be on that. Maybe just AGO opinion on this matter, and the attorney could work on that at a later date. That's just my takeaway from this, is that regardless of the motion that we entertain here today, that we do still seek an AGO.
Madam Chair, what would be the time frame you're talking about prior to this decision or?
Regardless of this
regardless
decision.
of this decision. And what benefit would it be in your mind?
So it's
At the
for
end,
every,
at the end, for
every
everybody.
municipality, every county. It would be nice. Now, it's not a binding, it's not legal, it's not enforceable. It is there simply to see, because they've not ruled on this before that I could tell. I read through all the AGOs. It would be there as a guidance in the future for other people. I would like to see it there for the residents that are involved in this, frankly, that we would have something, that we did at least try to get an opinion on it for the future.
Thank you. I just was
Yeah.
curious as to.
Yeah, I want to say it to be regardless of the outcome of whatever
Thank you.
we're doing. Thank you. That's my opinion.
Yeah, and I'd counter. I think this needs to be a clean motion. We can bring that up anytime in the future, but for
think you said
clarity's
you-
purpose, it just needs to be a clean motion on this item in front of us. At a future meeting, bring up. We
can do two motions.
Would you like that, Mr. Rodriguez? Would it be two motions on this? Would you need a vote or just a consensus for an AGO?
I'm trying to get confirmation from the AG's office on
Yeah,
exactly this
I think
issue,
it's
because it looks like the only requirement for a vote is on a question regarding to the powers and duties of officials who sit on boards, that I would need a majority vote. I don't think on a question of law of such that I need a majority vote from you guys to seek such an opinion.
So how about
but
in
that's
the-
something we can bring up. I think
So-
time-wise, we can bring that up at the next commission meeting.
Or we
whether
can bring it up in other items after this. That way we don't lose thought of it.
Yeah, make it a separate issue.
Okay, we'll put it in other items for discussion. So any other comments before we entertain a motion? A response?
I'd just like to say that, yes, I am not been a big proponent of this particular project. In my opinion, and in my campaign, I ran for growth. Growth is going to happen. I get it. Our county is prime for growth. I think Pam and I both, dealing with real estate on a daily basis, we get it. We get maps from our constituents showing all the development that's coming down. I mean, every ad in Flagler County is 5 minutes to the beach, 10 minutes to the beach, 15 minutes to the beach. Oh, you're in Flagler Beach. It's a big deal. Flagler Beach is a big deal. I get it. We need jobs. I get all that. My concern is smart growth. As I watch this project progress through the system that it went through, I just think that a marina of 150 slips is not necessary. Palm Coast has a 90-slip marina. I'm concerned about the financial impact on Flagler Beach. Their leadership is not, and that's fine. I can't change that. All I can do is look at what is presented in a time, and unfortunately, I think this board will agree that when we started looking at annexation within our county, it wasn't to pinpoint Veranda Bay or Summertown. It was an overall annexation protocol. This project happened to be one of the only ones that was in process. We get a letter of voluntary annexation notice from Bunnell, from Palm Coast, from Flagler Beach. We didn't just get one from Flagler Beach. We get them, I would say, once a month. So looking at annexation within the county is not a pinpoint. It wasn't just Flagler Beach that we chose to look at. It was annexation in general. I'm a citizen of Flagler Beach, and I'm sorry, but I disagree that annexation means more revenue. The revenue study that they gave us, or that they presented, did not show the real cost of annexation and what the future 20 years is going to look like. I also agree with those people that agree that this statute says a municipality is not constitutionally or statutorily authorized to vary the procedure for annexation specified in the general or special law. You know, I download apps every single day. I don't read. I have to agree to a form that's about 16 pages long. I go to the doctor's office. I got to read a form. I give consent. None of us read that stuff. I'm on the board at my HOA, and people come to every meeting not knowing what's in, what the bylaws are, never mind what's in the declaration and covenants. At where I live, the book is that big. I get it. It's my responsibility. They just changed the law in the state of Florida that giving more time to HOA, because the law right used to be you get 3 days to look over all the covenants, all the covenants, all the bylaws, financial statements, minutes from meetings. As a consumer, you're given those rights to do that. Well, in the state of Florida, we just changed it from 3 days to 7 days. That's how complicated some of these documents are. I agree, Mr. Gardner, the room does not have 120 people in it. I get it. I get it. Does that mean they're for it? I don't know. In Flagler Beach, if you don't show up, that means you're for it. If you show up and you're against it, it's hard sitting up here trying to make that argument, but I am very happy to hear Mr. Belchi state that his company will not back out. I think that would be, like you say, a very unethical thing to do. I don't quite know where I am with this, but I'm not the only leader on this, Mr. Schimento. In order to have today's meeting, we needed 3 votes, so I'll take the hit on this, but I think it's unfair. I think it's unfair that we can't look at both sides of the issue. This is overdevelopment. It's a clear overdevelopment. A marina the size they're trying to bring. I was against this in 2020 when it came before this board, and they moved 100% of their density to the east side, which left a big question mark on what was going to happen to the west side. So 6 years later, we find out what's going to happen on the west side. Again, it's all about density. It's always going to be about density unless you can train me on any other developer that's not focused on density. There's going to be an argument on overdevelopment. What one municipality wants is clearly not what the other municipality wants. I have a wetland delineation. I have a AG, agricultural timberland designation in one county and one municipality, and then we get medium density in another municipality. They're not congruent. You look across Bulow, someday we're going to look across Bulow in this beautiful park that we're building, and we're going to see trees and our egret nests and all of that, and then right within 50 feet, we're going to see 1,300 homes. So if that's congruent, and it's not congruent. So comp plans are meant to be congruent. This is purely a density issue. So that's my feeling on annexation. My comments on this particular law and how it applies is you can't change the way we annex in the state of Florida. So if the developer found a way to do that and his attorney agrees with him, or every attorney agrees with him, I can't speak to that. What we do in our job, in our capacity, is to get it right. And in this case, this board will have to decide if the city or the developer has the right to vary the procedure on how to annex. And as far as the comments about leaving February 13th with a handshake, that what was agreed to eliminated any future action on Veranda Bay, no one can speak for this board at any negotiations at any time. So whoever gave you full capacity or full knowledge that we couldn't do this today, shame on them, because they can't do that. This board is the one that directs what we do next. It's not in the agreement, so whether it was said or if somebody shook your hand, I wasn't there, so I don't know, but it's not in the agreement that we can't move forward with a discrepancy or a problem with Veranda Bay. So I'm with Mr. Royer. People are asking for smart growth, and I'm one of them. That doesn't mean I'm anti-development. I watched the process go from 2,700 properties. I think there was a combination of condos and single-family homes. I agree on that it's smart growth, and we can bring jobs and commercial at the same time.
That's it. Okay.
Miss, I have some comments.
Yes, ma'am.
Very briefly. I chose to be on this board to bring common sense, fairness, and do the best I could do for the quality of life for all of us. For Ms. Sandra, thank you for the comment. I'm the quiet one here, I think, in my own mind. I respect everybody has, and this is a very tough decision for me to make. And apparently, there's an appearance that I am in line with anyone else's thinking. And for those who know me, I'm not in line with anybody's sense of thinking. I am a very independent thinker. I have critical thoughts, and I listen to everybody, what they've said today. This is a huge, huge decision. But I want to do something that I think may be the best for everyone, and I want to leave it at that. I want to thank the Tanners for your passion and compassion for your community. It's very rare that residents stay so devout to believe in their own beliefs of their purpose. And I respect your beliefs, but it's not the only people's beliefs, right? Mr. Belchi, I respect your opportunity to try to stay to your direction and your cause. Mr. Chimento, I'm not like anyone else. I think you know that. So calling me out separately does not, I have my own mind. So no one in this room except everybody in this room will help me make a decision. And this is a very hard decision because this has been a battle, I guess, for a couple of years, right? So I'm thrown into this mix without no personal feelings on it whatsoever. I sit here as a judge to make judgments. I ask legal for what my rights are, what I can and cannot do as far as making judgments. So I feel comfortable when I make that decision. We've had a lot of conversation. My biggest concerns of Flagler County is trying to keep Flagler. I have been fighting for Flagler since I got here because I believe it's the most beautiful part of the state. But everybody's vision of beauty is different. I look in the mirror and I see beauty, and then I don't see beauty. So it's my decision today, and I just want to say that because my name was mentioned out separately. But I'm a different person than any of these people here, and any of these people here. I try to make fair and equitable decisions that'll be the best for our community. It is nothing personal, but I thank those who recognize that I do care about you too. So thank you for that. Thank you, Hannah.
Thank you. Mr. Rodriguez, I have one final question so they can weigh it. If this were to go to a 164, would our internal counsel be handling that on the behalf for the county, or would it be an outside counsel that you would seek?
No, internal.
Mr. Smith, would you know the answer to that for your group?
Let me clarify the question. The question was 164 process. 164 process will be internal for me and for county. I think you mean for litigation.
For the litigation, yes.
I would expect to be involved in litigation, but that's always the client's decision on who is involved in that.
Thank you, sir.
Right. And if you're separating the two, litigation would still
Yeah,
be
I'm sorry.
internal. I mean, I've done my fair share of annexation wars in multiple jurisdictions.
Yes, sir, I know that. Okay. I'm not going to drag us out any further here. I believe Flagler Beach thinks that they've acted in the best interests in regard to 171.044 in regards to signatures on petition. I don't have a level of comfort for that, but they are the ones at the end who will bear the burden of proving that they're right. I say that, but at the same time, I'm not comfortable with it. So I'm not comfortable that we're doing the best thing in the interest of the people that currently reside in there. I've looked at their covenants. Covenants say the right is to cause the property to be annexed. And here again, we're weighing, we're trying to determine which attorney has the smartest argument. Everyone's got an opinion on it, right? And that has always been the worst part of this job, is trying to figure out which attorney had the had the best argument. So I'm just going to go ahead and entertain a motion on it. We can discuss the AGO letter in the item 6.
Madam Chairman,
Just-
I move that we deny going forward with the conflict resolution procedure.
Second.
All right, I have a motion to deny by Mr. Hanson, a second by Mr. Dance. I'm going to go ahead and allow for a roll call vote on that.
Final comment, if I could?
Absolutely, sir.
Yeah, I just, with lengthy conversations with our
I know.
attorney, I just think that there's other avenues. An action here denying, the city of Flagler Beach this annexation doesn't preclude it from happening in a different form or fashion. But it does, in effect, disenfranchise our continuing relationships with the city. And I think that is understated, the fact that we have continuing work to do with our municipalities, and these are not the appropriate path to take at this point.
Well, so much of this could be avoided if we had stood up the joint planning committees,
Yeah, but we're not there. I
the
mean,
comp plan years ago. But anyways, understood.
Just a final thought. Thank
We have a
you.
motion to deny, a second, and I believe we're going to go for a roll call.
Commissioner Carney,
Request to be last? On a roll call?
No.
No.
that sets a dangerous precedent.
Yes,
Okay,
no.
no problem. I asked the question.
Okay.
What's the motion? To,
The motion is to,
I don't think it, is the word deny, we didn't
That's-
get
so-
to that point.
So you're,
Should the motion not be? that
motion
we-
is,
That we not move, that was the.
the
that was-
motion is to not move forward with
Correct.
it. So denying would be, the effect of the motion is to not move forward with 164
would
proceedings.
you like to?
I can modify
Amend.
mine to say I move that we do not move forward with the conflict resolution procedure.
I'll accept the second.
So the motion is to not move forward with the conflict resolution.
I vote yay.
Commissioner Hanson,
Yes.
Commissioner Richardson,
Yes.
Commissioner Dance,
Yes.
Chair Pennington.
No. Motion passes. We're moving on to other items needed for discussion as needed. First thing is, looking today, the administration brought this to me today, we're looking for a consensus to sign a letter in support of the preservation and renovation of the Palm Coast Fire Station 2022. It's a historic station, and they would like to repurpose it into a community-centered space. You're welcome to read the letter. They're asking that we, as chair, sign this. Does anybody have any objection to this?
Is that the one that's on Palm Coast Parkway? It's the old one?
That's correct.
I thought
Historic
it was going to go to Historic Society.
They were taking it, they were taking it, they were
I thought
taking
they were going to take it.
It says here, they're asking us to support the vision to repurpose the historic station into a community center space that includes a fire service museum, historical exhibits, and flexible meeting space for public program, education, and civic engagement. I think the city still has a role in it, and the Historical Society will oversee the historic.
Yeah, it sounds like it. Yeah,
That's what it
yeah,
reads
okay.
like.
Yeah,
So is anybody in support of this? I
yeah.
couldn't see.
Yes.
Okay, so I'm going to sign that right here, right now. Okay. All right. The next thing, while we're still on the topic of the last issue, my personal opinion is that it would help to have an AGO on petition signatures. It would help every county. We're in a situation where we have a good opportunity to put that forth and ask for it.
I'll make a motion that we,
move to.
we ask our attorney to seek an AG opinion on specifically this petition part of the annexation.
Second. You
Any
decide.
discussion on that? You want to?
Can anybody do this, or are we just taking a statement, is the motion to take a statement as the board? But can anybody request
It looks
an AG opinion?
Now, the Attorney General's office has specific guidelines on who can request opinions and what the subject matter of an opinion is. So, and that the opinion has to be a question of law. So if it could be an opinion being sought from a governing body, I think it's best that we have some type of a motion or action. And when requesting the opinion, I actually have to attach to the request at a minimum the minutes of the meeting saying that I have a majority of the governing body asking for this opinion, to show that it's actually the governing body and not just one elected official who's asking for the opinion. And the opinion would just simply be, we would ask to set it as a question of, we'd lay it out that, you know, in a case where you have a declaration of covenant and restrictions, which lays out such a scenario, would this be consistent with, for voluntary annexation under 171? It would be a general application of the law, so we would not make it specific to this instance, because what an Attorney General's opinion that would come back would basically have general application to the entire state of Florida.
Which is what we want.
I guess that would be just the request, is that it's a general
That's it.
statement,
Just be-
without it being specific.
Oh, no, it would, no, the question would simply be, it would be a question on a declaration of restrictive covenants regarding developer rights, regarding annexation and consent or non-consent of property owners. Is that sufficient to satisfy the Chapter 171 signature requirement? So yes, it would be general application. There would be no mention of Veranda Bay. There would be no mention. It would really be a question of general application. I mean, if someone wants to try to deduce it because the question happens to be coming from the county attorney for Flagler County, then that someone is going to have pretty specific knowledge of the events.
And it could take months to get back, correct?
It
And they could choose not to answer it also.
That as well, but most likely we probably would get an answer because it's something. I can assure you, in this case, now that the matter's been voted and we're moving forward, I have been reviewing annexation requests for, I can't believe it's almost been 30 years. I mean, I was the attorney who reviewed every single annexation application that came in Volusia County. I can tell you, this was the first time I ever saw an application for annexation that was for a platted community that had already sold its individual lots to third parties. So that's why this was one that completely, raised a flag. We're like, well, this is the first time I've ever seen where we've already had this type, and this is why the concern of, well, where are these other individuals because of the question of the signature. So it is a novel question of the law. But as I noted, there's novel questions of the law, and then there's the wisdom of whether or not you want to engage in battle or not. So, but the question would be one of general application and of general interest to the entire state of Florida. So that would be the way I would couch the question and request for opinion from the state.
We had to do it once because we wanted to buy fire trucks with infrastructure surtax money, right? Is a fire truck infrastructure. But the statute allows you to buy emergency equipment with it. So we got that answer back very quickly, and it was affirmative but we had it in writing that was a proper use. So I think that's all we're seeking here. I don't think it's to rehash anything. It's just.
Well, it would be guidance
right.
from.
Most of the annexations start before the plats are, before the development starts. So.
Most of the time, or you would at least have annexations prior to your conveyance of. You could have a plat, and you can have an annexation then after a platted lot before you've actually conveyed the platted lots to third parties. That's also the case. That's something I've done in the past as well. So, but in this case, yes, it would be the opinion would be advisory, and we take into account, especially moving forward when we deal with other annexations from this point forward. But mostly, it would be advisory and persuasive if it needs to be moving forward if litigation were to be involved.
Yeah, well, it might
separate
help
litigation.
it might help other counties in the state, too.
Correct, and cities as well.
It would be for the greater good of the state, period. Good idea.
Question?
Are we going to take the vote?
All right, so anything else, Mr. Diaz?
No,
Say
thank
on
you.
the topic, okay. I believe we had a motion by Ms. Carney to seek an Attorney General opinion regarding the situation, not specific to Miranda Bay, but just specific to having a voluntary petition, individual signature versus covenants, restrictions, verbiage. Did we have a second? We had a second for Mr. Hanson. We'll go out for public comment on this. It's not on. Do we need a public comment?
We could, but it's not, you're
Just a
directing
board
staff
thing.
to do something,
Okay.
so.
Okay, so you're good? All right. All those in favor signify with aye.
Aye.
Any opposed? Hearing none, I see that it passes. Any other items for discussion today? Anything?
Madam Chairman, I move we adjourn.
All right, sir, we're adjourned. Thank you.